Hi, Dr. Nadia. My name is Queenie Tang, student ID 036627. This is a dispute involves a bilateral treaty between State Aramaica and State Fortuna on a joint dam project on a shared river. State Aramaica unilaterally suspended the treaty, citing State Fortuna's material breach under Article 16. Fortuna in turn invokes two defenses under Article 61, 62, and 53. The food that represents our theme today is layered lasagna. The base pasta layer represents pata and savanda, the foundation principle of treaty law. The meat layer symbolizes material breach, a substantive layer that can disturb the structure if serious enough. Finally, the cheese topping represents jus cogens, the highest overriding norm that can nullify all underlying layers if violated. Lasagna also changes shape as it bakes, just like treaties can evolve in response to changing realities like climate change. So this dish illustrates both the layered hierarchy of legal norms and the flexibility needed in modern treaty interpretation. The first issue is whether State Aramica's unilateral suspension of the treaty, allegedly due to a material breach, is lawful. According to Article 26 of the VCLT, every treaty in force is binding upon the parties to it and must be performed by them in good faith. And this principle obliges states to implement treaty obligations sincerely and not to undermine the treaty's purpose. And this is further supported by Article 60, subclause 1 of the VCLT. If one party fails to comply with this principle, the other party may also choose not to apply the treaty with respect to the defaulting party by terminating the treaty or suspending its operation in whole or in part. In Ware against Hilton, it was argued that the Treaty of 1783 between the United States and Great Britain had been suspended due to Britain's failure to fulfill certain obligations. And Mr. Justice Iredell emphasized if a treaty be violated by one party, it is at the option of the other innocent party to declare that the treaty is void. Similarly, in Ray Thomas, it was stated where a treaty is violated by one of the contracting parties, it rests alone with the injured party to pronounce it broken. However, it is often very difficult to identify the object and purpose of a treaty and whether a breach treaty provision is essential to its accomplishments. In treaties containing interdependent rights and obligations, one must consider both the degree of interdependence and the significance of the breach provision within the overall framework and spirit of the treaty. A breach must be sufficiently serious to undermine the implementation of the treaty's objects and purpose. Minor or technical breaches would not justify suspension or termination. In this context, if Fortuna's breach safeguards are central to the treaty's objects and purpose, such as ensuring sustainable joint dam management, a repeated and substantial breach may indeed amount to a material breach. In such a case, Aramaica and innocent parties' unilateral suspension could be justified under Article 60 of the VCLT. However, if the breach is minor, technical, or reasonably disputable, then suspension will likely be premature or unlawful. And this principle is further illustrated in Hungary against Slovakia, where the International Court of Justice held that Hungary was not entitled to unilaterally suspend or abandon the project. The court emphasized that both states were required to negotiate in good faith in light of prevailing situation and to take all necessary measures to ensure the achievement of the treaty's objectives. Accordingly, if State Aramaica invokes a suspension of a treaty, it must comply with procedural steps under Article 65 of the VCLT. It must notify the other party, State Fortuna, of its intention to suspend the treaty and indicates the measures proposed with respect to the treaty, along with the reasons for such action. If State Fortuna raises an objection, State Aramaica must provide an opportunity for dispute settlements in accordance with Article 33 of the UN Charter, for example, through negotiation or arbitration, where applicable. Failure to fulfill the to fulfill these procedural requirements may render the state's Aramika's suspension unlawful, even if the breach itself is immaterial. Moving on to the second issue, whether State Botuna's defenses are valid. With regards to the terminating of a treaty, limitations are imposed by Article 45 of the VCLT. Under Article 62, terminating or withdrawing from the treaty is permitted only when a change of circumstances, firstly, is fundamental and has occurred at the time of the conclusion of a treaty. Secondly, was not foreseen by the parties. Thirdly, constituted an essential basis of the treaty. And lastly, radically transforms the extent of obligations still to be performed. And this is supported by the fisheries jurisdiction and Hungary against Slovakia cases, where it was held that for a treaty to be terminated due to a change in circumstances, the change must fundamentally and radically alter the nature or scope of the obligations still to be performed. Additionally, Article 61 subclause 1 provides that a party may invoke the impossibility of performance as a ground for terminating or withdrawing from a treaty only if the impossibility results from the permanent destruction of the treaty's object. In the present case, while climate change might qualify as unforeseen in scale and impact, Article 62 is narrowly interpreted. Accordingly, Botuna bears the burden of demonstrating that the climate impacts amounts to radical and unforeseen transformations that have fundamentally undermined the basis of the treaty, such as joint sustainable dam operation, or else its arguments under Article 62 is weak and not valid. Botuna also has to prove the performance of the treaty is permanently impossible. However, for the facts, Botuna seems to have added in a way that defeats its own arguments. If Botuna failed to formally protest for a prolonged period after becoming aware of the alleged environmental impact of climate change, Article 45b may be triggered, and this would mean Botuna acquiesced to the treaty's continued operation, undermining its ability to invoke rebus sic stantibus now. Even if Botuna cannot meet the strict thresholds of Article 62 or 61, it may still request treaty modification via good faith negotiations, especially in light of modern environmental standards or precautionary principles. Under Article 53, a treaty conflicting with jus cogens norm is void. Under Article 64, if a new peremptory norm emerges, any existing treaty which is in conflict with that norm becomes void and terminates. Lord McNair stated many rules of customary international law which cannot be set aside by contrading states as being necessary to protect the public interest of the states or to maintain the standards of public morality. In the present case, to qualify as a jus cogens norm, a principle must meet a high threshold of universal acceptance and non-derogability. If access to clean water were accepted as a peremptory norm, it could override treaty provisions, particularly if the dam directly violates these rights by compromising downstream access to clean water or causing water pollution. The third issue is whether environmental obligations can evolve into jus cogens norms overriding treaty provisions. Currently, no environmental obligation has been universally recognized as jus cogens. However, there is a developing trend in international law suggesting that certain fundamental environmental principles, especially those essential to human survival, such as protection against catastrophic harm or to the planet's ecological balance, could evolve into jus cogens norms. For instance, Dina Shelton, in her writings on environmental rights, emphasized that the right to a general, satisfactory, and healthy environment obliges the states to take reasonable and effective measures to prevent pollution and ecological degradation. Accordingly, if environmental destruction threatens the survival of humanity, it must be placed on the same normative plane as other peremptory norms. Similarly, in Hungary against Slovakia, the ICJ recognized the importance of environmental protection, noting that it constitutes an essential interest of the state under Article 64 of the VCLT. Accordingly, environmental protection is increasingly recognized as an emerging erga omnes obligation, grounded in customary international law and also the potential developments of a jus cogens norm. And this is supported by widespread stat practice and binding expressions of opinion juris, reflecting in instruments such as the Rio Declaration 1992, the Paris Agreements 2015, and the UNFCCC 1992, which all express strong international consensus on sustainable development, climate change mitigation, and also the environmental protection. As such, tribunals should begin to acknowledge and give effect to this evolving obligation. In the present case, the link between environmental degradation and rights to life, health, and water access further strengthens this possibility. Still, the threshold for recognition as jus cogens remains high. Despite the growing momentum, several legal and practical challenges remain. First, not all states accept environmental protection as a peremptory norm. Jus cogens norms require near universal or very large majorities of states' recognition. Second, unlike clear prohibitions such as those on torture or genocide, environmental obligations tend to be broad and varied, making it difficult to determine which specific obligations might rise to the level of jus cogens. As of now, environmental obligations alone are not recognized as jus cogens. However, derivative rights such as the right to access clean water may eventually be recognized as jus cogens norm. The fourth issue is how these competing principles interact in this scenario. Generally, treaties are binding and must be performed in good faith under Article 26 of the VCLT. In the present case, State Arabica asserts a material breach, while State Fortuna invokes jus cogens and rebus sic stantibus. Both parties are therefore relying on exceptions that test the limits of peta sunt servanda, and this principle remains binding unless successfully overridden by material breach, rebus sic stantibus, or a conflict with a jus cogens norm. A material breach under Article 60 allows derogation from peta sunt servanda, but only when properly substantiated. Here, Arabica claims that Fortuna repeatedly violated environmental safeguards, thereby undermining the treaty's object. If proven, this may constitute a legitimate ground for suspension, modifying the strict application of peta sunt servanda. However, procedural safeguards under Article 65, such as notification and opportunity for dispute resolution, must be followed. Otherwise, peta sunt servanda remains in force. In contrast, jus cogens norms are recognized under Articles 53 and 64 as peremptory norms from which no derogation is permitted, and they take precedence over peta sunt servanda. Here, Fortuna argues that the UN General Assembly's recognition of access to clean water reflects a newly emerged jus cogens norm. If such a norm exists and the dame's operation interferes with downstream access to clean water, the treaty would be ultimately void or terminated, regardless of parties' consent, unlike material breach, which allows suspension based on parties' conduct. The principle of peta sunt servanda has traditionally been viewed as static, binding states to the treaty obligations regardless of changing circumstances. However, in an era of climate change, this rigidity poses significant challenges. Accordingly, a dynamic peta sunt servanda model is essential, one that interprets the duty of good faith treaty performance to include a continuing obligation to interpret and apply treaty provisions in light of new environmental realities, rather than relying heavily on Article 62, which is rebus sic stantibus for treaty termination. And this approach promotes treaty adaptation and also evolution. Such a model would align with the principle of sustainable development, which is increasingly recognized as a general principle of international law. Ultimately, courts and tribunals are likely to adopt a balancing approach, weighing treaty obligations against evolving human rights and environmental imperatives. If strict legal thresholds are not met, interpretive flexibility and constructive renegotiation remain the most viable pathways forward, particularly in environmental treaty context. And this is the references. That is all from me. Thank you for listening. Bye.